Record. All right. So thank you, everyone, and thank you for joining me. It's Thursday morning. It's 11 a.m. As always, these Zoom trainings are always going to be same time, same login information. And we are doing the last Thursday of the month. We should be doing live in the office. Sometimes we may need to do schedule changes with the live, but mark your calendars every Thursday. You should have an alarm going off on your phone to remind you to log in. Couple just housekeeping before we jump into today's. Just a reminder that Carla Wynn is working in our Parkland office now. Carla is with South Florida Title Associates. She is there to help you with any needs that you may have as far as title. South Florida Title Associates still is one of the most competitive rates in the industry, besides the fact that we are here to service only United Realty agents, and we give you guys our foremost attention so you get that level of service for you and your clients. And if they find a less closing fee somewhere else, we will always match that fee. So just check with us. Next, if you haven't used us already, Certified Home Loans is our in-house lender. I am the senior loan officer for this branch. If you have any buyers that need approval, please reach out to me. We do get some of the lowest rates. We get sometimes same-day turnaround. We're getting appraisal waivers and so forth. Besides giving you guys the best service, you have a lender that's sitting in with you. We can even expedite and get you a 7-day approval if need be, and get that quick appraisal and pay for it to be expedited. And we will pay on behalf of the buyer for any expedited fees. But let's just jump into today's topic. So everyone read it. It was about keeping it legal. We all worked so hard to get our license. And for many of this is our sole source of income. This is what we use to pay our mortgage, to feed our children, and our families count and rely on us. So our license is extremely valuable to us. So losing it or having to pause it for any time could potentially, hurt someone's livelihood. I also like to think about my reputation. I never wanted to ever hear that someone makes a claim against me or a complaint for any reason because I violated something unethical. Then there's also that I always want to make sure I'm doing what's best by my buyer and my seller, and making sure that I'm protecting them every step of the way. So as always, once a quarter, I do this legal discussion, and I like to take topics that came up throughout the quarter and let you guys know, because these are the ones that you are encountering every day while you're out there and going forth. So these are in no particular order, and they are not directed at anyone. If it happened to be an issue you have, it's just I want everyone to learn, because just as always when we were children, we can only learn and grow from things that happened in the past to us. I don't always like to say mistakes because some of them weren't mistakes, they were just errors. So let's learn and grow from it. The number one thing on my list is renewals. We all know we have to renew our license every 2 years. We just went through it on March 31st, half of you fall, and on September 30th is the other half. But people go and do their continuing education and they think, I'm good, I did my continuing ed. Take it a step further and remind yourself that you have to go into DBPR. You have to renew it in DBPR and pay the renewal fee. If not, your license goes into an inactive period. And if you're not cautious of it or it slips your mind, the one felony that we can do as real estate agents is practicing without a valid license. So I hate to say it, but if you don't renew and remember to pay that renewal fee and you go out and you're showing property, you are committing a felony. So not only is your license at risk, but you're also at risk of doing a felony. RESPA reminders. We all know kickbacks are prohibited. This includes anything of value, sporting tickets, even a gift card to a restaurant, anything of value. And it is not just between you and a loan officer or title company. It could also be home inspectors, insurance companies, appraisers. If you are doing anything to send a client to them, that is considered a kickback, or if you're trying to get a referral from them by giving them something. Just a reminder. So leasebacks. Leasebacks are really come along a lot now. People are waiting to find a property, and sometimes they need to stay a little bit past the closing date. For starters, let's make sure it's always in writing to make it effective. Next, always remind them to check with their insurance coverage to make sure that the buyer's insurance company is okay with them having somebody else in the property and it covers them. And the biggest thing on it is you need to make sure if it's over 60 days, just a reminder is most lenders will not approve of that, because over 60 days, it becomes that they have a tenant in there. And when people take out a mortgage, they are taking it out and they check off that it is their primary residence. It's not being used as a rental property. So if it goes over the 60-day limit, we could be putting ourselves in mortgage fraud, and you could be assisting in it. So make sure if it is ever more, that whatever the length is, it is approved by the lender as well. The next is something a lot of us probably don't think about, is recording devices. Nowadays, a lot of people have recording devices, not only on their Ring doorbells, but sometimes they have cameras somewhere within the house. A lot of people have nanny cams, or they have cameras set up for their pets. Well, as we're having people come in and out of the house, and recording people could violate some laws, we need to disclose that. So the way I would do it as part of my listing routine is I tell the seller that they must disclose of any recording devices that are in the home. And then I disclose it in the MLS in the broker remarks section. Please note that the seller has a recording device in the living room or wherever it's at. And the reason this is really important is sometimes when they're showing, the agents are having very private conversations, and it could be that we're not doing what's best for the buyer. If the buyer says, well, let's offer 900, but we'll definitely go to 950, and we just record it that we are in a little bit of a violation, and so is the seller. Besides, there are certain state laws that apply to recording someone unknowingly. So make sure you address that and warn them of any legal risks. The next on my list is rebates to buyers. Typically, our Florida statutes read that we cannot give a commission to anybody that is not licensed. However, there is an exception in our Florida statutes that states sharing brokerage compensations by a licensee with a party of the transaction with full disclosure to all parties is not considered a violation. So this means if you decide that they're going to give $1,000 to your buyer, or 500 or whatever it is, that needs to be disclosed to all parties. So it needs to be signed by the buyer and the seller, sent to the lender, and obviously title. So this way, everyone knows it's disclosed that X amount of money, United Realty Group is lowering their commission by X amount, and it's being credited to the buyer at time of close. Always have to make sure that the lender approves it as well, because some lenders will allow it, some will not. Some only allow a certain amount, so that must be done too. Now, as far as advertising that rebate, which it's okay, agents have asked me, can I advertise that I will give a $500 rebate to anyone using my services? You can. Always be certain that it's not false, it's not deceptive, and it's not misleading. And if there are any certain terms or conditions provided, let's say the sale has to be over $150,000, or it's only for sales, it's not for rentals, you need to make sure that is disclosed very clearly in the ad, and it is that it is straightforward. I'll give you, and remember that you need to use very specific language on this, and it cannot be used, your limitations cannot be used to persuade a client to use a certain vendor. And I'm going to give you an example of this. Years ago, I had an agent in my office, and her spouse was a loan officer. And what happened was she agreed to the rebate as long as they used ABC Mortgage Company, which was her husband. Well, guess what? That was considered RESPA kickback, and they were in violation, and her license is null and void at this point. actually, or revoked. Because they did put in a complaint with it because they forced them to use that in order to get this. So that really can't be one of your conditions. Next is I'm going to go with fair housing. We all know fair housing and our guidelines. We've been taught this. We've gone over it. You learned it when you were in before you got your license in FREC 101. What people don't realize, and it's been going on for decades, is there are testers that are in place by the Fair Housing Administrative. And these testers, basically what they're doing is they're looking for keywords, and then they may or may not call to further investigate if a violation of fair housing is being committed. Certain keywords, I'll tell you, is no children, no criminal background, and the biggest one, no Section 8. We are not allowed to discriminate against Section 8. So if you put that in any of your listings, always know that you may get a tester coming and saying, we're interested in this. There's always a chance. So be very careful of that. If you're not familiar, go read the fair housing laws and make sure that you are completely adhering to them. My next is, we had somebody come up recently with multiple offers. Do I need to respond to all the offers, or do they need to give a counter to all offers? The answer there is no. There is no Florida law that says that any seller must at least counter, that they have to negotiate, that they have to respond to an offer. There's no Florida law that says that. However, my suggestion to you as an agent is when you do get multiple offers, always make sure on that last page of the contract, it has seller counters or seller rejects. I would have them check off the box, initial next to it, and send it back to the agent that sent the offer. You never want them to say that maybe you didn't present the offer, because especially if it's a full price offer and they can't understand why it was rejected. And then maybe there was a situation where it might have been your buyer and they see it close out in the MLS. There's a really good chance that that agent may put in a complaint saying that you never presented their offer. So this way you take away any uncertainty. Next is procuring costs. People will say, well, I show them the property and then somebody else submitted an offer. Well, years ago, they stopped doing procuring costs. And the reason being is that the buyer can choose to work with whoever they want. And even though you might have taken them out for 3 Saturdays in a row and showed them that particular property, if they chose to have another agent represent them in the sale, that is the buyer's decision. For whatever reason they chose, it is theirs. So procuring a cause does not really exist, just so everyone is aware. Calculating deadlines. Years ago, our contracts did read some of our deadlines were at the end of the calendar day, and some of them read by 5 p.m. Well, at this point, none of our contracts read by 5 p.m. They all read by end of the calendar day, which is 11:59 p.m. So that is the deadline, just so everyone is aware. If you're working with an LLC or any corporation that is either the buyer or the seller, just so people have asked me what name goes underneath it, who's signing, does it go the LLC's name? Do we type that out under the line? It is the name of the signer that is typed out. They are the one signing. But I'm also going to take this a step further and tell you to go into sunbiz.org. Look up the name of the LLC or the corporation. Make sure it's a valid LLC and corporation. Next, I want you to make sure that they are either a sole proprietor or how many officers and directors they are. Because if there's more than one officer and a director, you need all signatures for all officers and directors would need to sign for a listing agreement or a sales contract if they're purchasing, just so everyone is aware of that. Now, let's also take this a step further and say, and it happens all the time, somebody calls and says, hey, my mother, my parents, somebody passed away and we're selling their house. Well, it doesn't mean that they have the right to sell it right then and there. Sometimes it's going to have to go through probate. Chances are it does. But what you can ask them is there a will in place? that gives you the authority to sell this. Ask them to provide you with the will. Now, it's not your job to know if the will, how the will reads. We're not attorneys. We're not that. However, you can bring it to South Florida Title Associates. They will tell you if it is addressed in it, and they will give us clarification if they feel we need to speak with a probate attorney, or if they say, yes, this person was set as a designee to sell the property through the will. Don't take it upon yourself to interpret it, but always make sure, because you don't want to go there and go to contract and then find out that the title company is going to say to you, we can't do this. And then you've just put yourself in a position along with other buyers and everybody else. The next is on my list is, and it's kind of been an ongoing thing in South Florida, is either fake landlords or fake sellers. And sometimes this has happened. People approach you and they say they want to sell the house. You look at the tax rolls and it says they live out of state. I would suggest always getting a driver's license and asking them for a copy of it to verify if they're them, if you don't know the person, especially if you look in and it seems like the property's been vacant for a while. Make sure of that. The same thing with landlords. People are renting property. If you're representing the tenant, make sure that the person who is the landlord is who they say they are. Just always ask for ID and do a little research on the property. Unfortunately, we have to do that these days, right? Spouse's signatures. Does the spouse need to sign? Absolutely, yes. Everyone on the deed needs to sign a listing agreement. If on the listing agreement, if more than one person is on the deed, all those people need to sign. The other way to know if the spouse needs to sign or not is very easily. When their deed was conveyed to them, when they purchased it, and it's all in our tax rolls, it's all public record, it will say behind it, Linda Bly, a single woman or a married woman. If it says married woman after it or married man, then it was at the time of marriage, they were at the time that they purchased it. So you need to have that person sign as well. And the reason for this is, unfortunately, people have done this and they're going through divorce. And one spouse goes, well, I'm going to sell the house, and they sign a listing agreement with you. And they haven't properly been divorced yet. And it's not, then you get to closing and the wife says, I'm not going to sign, or the husband says, I'm not going to sign. So make sure you're covering your base. And it's very easy. It says it right in their deed when it was granted to them, if they were a single or married. Buyer fails to make an EMD. People think that this means there's no contract. This does not mean that the contract is null and void at this point. This just means that the buyer has defaulted. So the buyer can technically go and make it a deposit later, and we're still under contract. It depends if then it's up to a seller whether they want to act on the default or not and stake a claim on that escrow. But it does not automatically mean that they are out of contract. There's still an existing contract in place. And if it doesn't move forward and there's never an EMD, the seller does have a right to go after him, but that's civilly. We don't have money in escrow, so it's not an escrow dispute. They never put it. They walked away for whatever reason, but they could go after him civilly. It could be a waste of time, but that's their decision whether they do it in a court or not. FAR leases. There's nowhere in our leases that it requires a written notice to renew or not. So people think when they're representing a landlord that they've told them they have to give you a 60-day notice. It's not in our leases. So you may want to write it in if you're representing a landlord to protect them further. You can also write in things that if they are not renewing, that they need to comply with showings, and it keeps them from having gaps. So this way they aren't unaware if the tenant's moving out or not, and you can relist it for them the following year. And with that, I just want to remind everybody that the lease supersedes the contract to lease. It doesn't matter what's in a contract to lease. That's just an intent to enter into a lease. Whatever is written in the lease supersedes. And sometimes there's things in there that weren't in a contract to lease. There's a lot of other terms. The contract to lease is just 2 pages, and our lease is 14 pages. So there's a lot of other terms and conditions that maybe now they don't want to sign it, and it doesn't hold them obligated to sign it as well either. But if that is the case, they may want to seek an attorney's advice. Dual variable rate. This is when you enter a listing. Now, most agents think that this means if the listing agent and the buying agent are getting two different compensations. For instance, I take a listing at 6%, I offer 2.5% in the MLS, and I keep 3.5%. That is not dual variable rate. What a dual variable rate means is if the buyer is represented by a cooperative agent, it is paid one commission rate. And if I, as the listing agent, represent the buyer, the seller would pay a different rate. So to make this seem a little easier for you to understand, I often write into my listing agreements that if I represent both buyer and seller in the transaction, I reduce my commissions from 6% to 5%. Therefore, instead of me offering 3%, like I am in the MLS, I am now offering myself, it would only be 2.5%. So that is my variable dual rate. The next one on my list is if the transaction fails and the property is in escrow dispute. So we did not close, but neither party is ready to release the escrow. We're disputing on it. A lot of agents think that the seller cannot relist the property and market it and go to it. That is not true. As if there's an escrow dispute, we can still market the property, we can go to contract, and we can sell the property. The escrow dispute will still go on. However, if there are other legal issues going on besides just an escrow dispute, they may want to seek an outside attorney. Don't always, we can't advise them on an attorney level. Remember that. Now, here's another big one. The contract, the buyer needs to qualify for the mortgage by selling another property. However, they don't attach addendum V, which is the contract, which is that it's subject to the sale of another property. So they don't attach that, and then we get the loan approval. And one of the conditions is that they may want to sell, that they have to, or they have to sell, I'm sorry. This is not considered a loan approval, being that it's subject to the sale of another property. At this point, your buyer has 3 options and 3 options only. They can either terminate prior to loan approval timeline, to the expiration of the loan approval, to secure themselves if their property hasn't already closed and sold. They could risk it and say, well, we're only a couple weeks out of selling, I'm pretty sure it's going to close. But then they must know that their escrow deposit could be up and at risk. Or you can go back and renegotiate with the seller and ask for an extension of loan approval, would be my suggestion. So, but that doesn't mean that because that condition is that we have loan approval. However, if we go past loan approval date, like our contract reads, it is deemed that the financing contingency is waived. So be very careful of that, because a lot of people think, oh, we don't need to, but it is a condition of their loan, and they're still not going to get financed if that house doesn't sell. A cancellation notice. We've all probably been in a situation where something comes up on the inspection and they decide they're not moving forward, and they just send over a cancellation notice and it's not signed, and that the contract is then terminated. Well, the verbiage in our contract reads a little bit different than that. Keep in mind, those cancellation note addendums, just as a buyer and seller agree. And if it's only signed by one party, it's not effective. The way our contract actually reads is that the buyer may terminate, in section 12, may terminate by delivering written notice to seller prior to expiration period. So they have to deliver a written notice. Now, section 18O allows us to deliver as a licensee, to deliver on behalf of the buyer. So what you should be doing is sending an email, because it's considered written notice, and it has to be sent to the seller, the buyer is electing to terminate the contract for sale and purchase as per section 12, they're exercising their right as per section 12. Please refer to the attached cancellation and release. So make sure you're also adding that verbiage in the body of an email to protect your buyer 100%. And the next is the washer and dryer. Folks, it is not listed on the contract. If you do not write it in, it is not part of the sale and the seller may take it. I can't say it as clearly as that. And it comes down to it. And if you fail to do it and it's on you, you're probably going to end up buying the buyer a washer and dryer because they're going to be upset. In addition to this, let's talk about personal property, because there is a line on our contract to write in any additional personal property that may be included with the sale. Now, let's throw something out there and say a hot tub. And then they come to find out that the hot tub isn't there. And the agent says, well, the MLS said it was included. The MLS does not prevail here. What the contract governs the terms of what is conveyed and not conveyed. Because that is all negotiated, even though the MLS says it, maybe they accepted a lower price with knowing that the hot tub wasn't included in it. I can't say that. Just know, just because the MLS says it's included, if it is not written in the contract governs the terms of what is conveyed at time of close, not the MLS. Now, people have also said in that section where it does say things like garage door openers, storm shutters, and it says that it's included in the sale. And then it's not there when they move in. But the verbiage actually says that it is owned by the seller at time of initial offer. So we had one recently and it was crazy. It was a whole lot of fuss over a garage door, the clicker. The seller didn't have them. He didn't have them for years. And they were fussing over a garage door clicker and they were upset that it wasn't there. And he never had one. So to me, it was the silliest of things, because literally you can buy universal ones on Amazon for like 20 bucks. I don't know why it was such a big deal, but it came down to it. Shutters too. Maybe there's not shutters for the whole house. If they didn't own them at the time, they didn't own them at the time. It came down to accordion shutters. They have to have that key to lock them. They were assuming they were getting the key. The seller never had them. They didn't get them from the first time, and it became an issue because now they could not lock the accordion shutters. The next on my list is to watch out for is our contracts and addendums. We have 3 contracts. The most commonly used one that we use now is the as is. Then we have our standard FAR bar, which is a little bit different because it doesn't automatically give the buyer an out. So that's why we use the as is. And it holds the seller obligated to pay a certain amount of repairs. And then we have the CRSP, which was put in. Now, we also have different addendums for these contracts. For most of us, we are using as-is contract. That's the most commonly one. With that, we should always be using the CR addendums. These are the comprehensive riders to the FAR bar addendums. A lot of agents make the error and pull the CRSP addendum. These are not addendums to those contracts. They go specifically to the CRSP contract. So just always pay attention. Does it say CR, comprehensive rider? That goes to our FAR bar and our as is. If it says CRSP, then it goes to our CSP contract. And I don't know anyone who uses the CRSP. It's gotten a short-term crispy, and I actually came out several years ago and I've never seen it used once. So there you have it. Any other big thing I want to remind everybody, because we are coming up on it. June 19th is now a national legal holiday. So when you're calculating timelines in it, if it falls on June 19th, as per our contracts, it reads if it falls on a national legal holiday or a Saturday or a Sunday, that it carries on to the next business day. So just be aware of that. I don't even know if it's a Saturday or Sunday this year. I'll pull up my calendar, but it is June 19th is a Monday. So just remember that if you're calculating any contracts, it will be carried on to Tuesday if that is the day it falls on. So with that, I hope a lot of these legal things have helped you and it can protect you. As always, I'll continue to do them about once a quarter. And I always just bring up topics that we stumbled across. If there's anything else that you always have any questions, concerns, or conundrums on, please reach out to me. If there's any verbiage that's additionally written in that by a co-op agent and you want me to review it to make sure you're protecting your client, please send it over to me. I'm happy to do it. If you want to add any other extra verbiage to protect them and you're writing it, please reach out to me. I'm happy to help you, especially if it comes into that you want to write escalation clauses, or if you want to say that they're going to pay over appraised value. I know I've mentioned it a couple times, maybe not everyone on this call today has heard it. I had not long ago, an agent wrote that the buyer will pay $10,000 over appraised value. The value appraised at purchase price. However, they did not put not to exceed purchase price. So it obligated the buyer to pay $10,000 over the appraised value. So that buyer's agent didn't make any commission because she ended up crediting it all to her buyer because she did not rate it correctly. So 2 little words, not to exceed purchase price, cost her entire commission on the sale, just about. Like she probably made like $900 after she paid that. So be very, very careful. You don't want to do that. And you don't want to run into it. Besides the fact that your reputation, besides cost, is well more than that, because we rely on our referrals. The biggest thing we get is at the end of each sale. I hope you are satisfied with my services. Who else do you know that could use my services? If I didn't make them happy and I did something wrong, they are not going to refer me. That's the biggest part of everyone's business. Most people's business is about 70% referrals. So just keep that in mind. As always, just a reminder, we'll be back at this next Thursday, same login, same everything. I'm right at that 30-minute mark. I never like to go over. I know everybody's time is valuable. Any questions, concerns, or conundrums, you can reach out to me. For those of you that jumped in the middle, I will post this on our Facebook page later today, so you can watch the beginning of it. If you haven't been to our Facebook page, please go and like it. It is United Realty Group Park Creek. So make sure you go like it, and you'll see, and there's tons of my other past training videos on there. Feel free to watch them and maybe learn a little something from it. And with that, I hope everyone can go out and make it a great day.